Thank you very much, Acting Speaker. And I too rise to address the Justice Legislation Amendment Bill 2024 before us today. And from the outset, Acting Speaker, can I acknowledge the contribution of my colleague, the Shadow Attorney-General and the member for Malvern earlier in this place, and thank him for the detailed work he's done on the bill before us today, and endorse wholeheartedly the remarks he made earlier today, the comprehensive remarks he made in relation to the justice legislation we are debating in the chamber this afternoon. Acting Speaker, I note that this bill has its origins back in 2018, some years ago now, and in reference to the Victorian Law Reform Commission to review and report on Victoria's committal system. The Commission was asked to recommend any legislative, procedural or administrative changes to Victoria's committal procedure which could reduce trauma experienced by victims and witnesses, improve efficiency in the criminal justice system and ensure fair trial rights. The VLRC came back in 2020 and made 51 recommendations around committal proceeding reform. And I note that in that report, the VLRC noted that each year approximately 3,000 criminal cases go through some form of committal proceeding. Around 30% of these resolve in the Magistrates Court, around 60% are committed in the county court to the county court, around half of these are for trial, the other half for sentencing following plea of guilty in the Magistrates Court, and a further 4% are tried or sentenced in the Supreme Court. Following that finding, the VLRC came back and made those 51 recommendations, and there has been a view for some time now within the legal community, the legal fraternity, and I note that this is not unanimously held, but nonetheless a view that has been put that committal hearings can lead in some instances to a double handling of evidence in criminal proceedings. There is also a view that reform to the committal procedure and the limitation on the use of cross-examination may help make the criminal justice process less distressing or traumatic for witnesses and victims. And I note that the bill before us today does go to addressing and reducing potentially the impact of cross-examination and the traumatic impact of cross-examination on witnesses and victims of crime. Acting Speaker, as has been raised today, several other jurisdictions in Australia have moved to reform and streamline their own committal processes in similar ways. So in that context, I note specifically this bill does remove the test for committal. It extends the prohibition on cross-examination to other proceedings and strengthens the test for granting leave to cross-examine. Acting Speaker, as the member for Malvern spoke to at some length, there are views from the Victorian Bar and the Criminal Bar Association who oppose key amendments in the bill before us today, including the removal of the test for committal and the extension of the prohibition on cross-examination. They assert that the committal process is a fundamental safeguard in our justice system and ensures that charges where a finding of guilt at trial is highly unlikely or impossible do not proceed to the trial court. This saves alleged victims, witnesses and accused from unnecessarily undergoing the trial process. Regarding the changes to the rules governing cross-examination, they argue that the strength of any prosecution case only becomes apparent once witnesses are required to face cross-examination. It is at that crucial point that deficiencies in the evidence become apparent. Given these concerns expressed from key members of the legal fraternity, I do suggest that the government seriously consider the member for Malvern's reason amendment and commit to reviewing the implementation of the bill to identify and remedy any demonstrable unfairness to defendants that may arise as a result of the changes contained within this bill. And I note the member for Malvern spoke about the VLRC report and the fact that the bill before us today, the government does appear to have cherry-picked from the recommendations, in that we are looking at removing the test for committal, but the review also recommended that the Criminal Procedure Act should be amended to provide that the accused may apply to the Magistrates or Children's Court for an order that the accused be discharged and empower the Magistrates and Children's Courts to discharge the accused on the relevant indictable charge or charge if satisfied that there is no reasonable prospect of conviction. Now, that recommendation, a very important safeguard that was included in the VLRC's report, is not included in this bill. And so I do support the member for Malvern's reasoned amendment that goes to addressing that very issue to explain why it has rejected the Victorian Law Reform Commission's recommendation to empower magistrates and the children's courts to discharge the accused on a relevant indictable charge or charges if satisfied there is no reasonable prospect of conviction. That does provide a safeguard to the complete removal of committals as this bill prescribes. Acting Speaker, the member for Malvern's reasoned amendment is especially precedent given the government's track record when it comes to criminal law reform. Let's not forget that at a time when alleged offender incidents by 10 to 17-year-olds increased between June 2022 and June 2024, and that youth crime is at its highest in a decade, the Labor government pushed ahead with their plans to actually weaken Victoria's bail laws. At a time when we've seen youth crime spike by 20%, we have seen criminal incidents in Victoria increase by more than 10%. But youth crime figure is at 20%. And we have seen this government in March this year weaken Victoria's bail laws. I've spoken about these issues at length in this place, and that is because I have local shop owners in the electorate of Kew that have been held at knife point too many times. I have residents in the electorate of Kew that have had their homes broken into at night when their children are asleep and they are afraid to be in their own homes. I've had local small businesses with their shop fronts smashed in. I've had their fronts rammed by trucks with ATMs stolen. It is unacceptable that this government continues to see youth crime in this state rise and rise and rise, and their answer to it is to weaken Victoria's bail laws and pretend there is not a problem with youth crime in this state. I've met with many local residents in the electorate of Kew. In fact, not a day goes by where someone doesn't contact me about the issue of the rising crime rates. When we look at the city of Boroondara, shop theft is up 31%, aggravated robbery is up 65%. And as I said, every week I hear about residential break-ins and thefts, and this isn't surprising given that residential aggravated burglary is up 23% in our area. Just recently, Acting Speaker, I met with a group of very concerned local residents in the area of North Balwyn. Now, North Balwyn is a beautiful part of Melbourne, and unfortunately, though, it sits on the leaderboard, very high on the leaderboard in terms of the number of aggravated break-ins in a suburb in Victoria. It's completely unacceptable that Victorians do not feel safe in their own homes because this government fails to actually put in place laws that prevents crimes and prevents offenders from reoffending. You speak to the local police who do work so hard in our local communities with a lack of resources, and they will say that they will arrest an offender overnight and by morning they have been bailed, and they've been bailed again after they have been arrested time and time again. The pendulum has swung too far to protecting the perpetrator and not protecting the victim, and this Labor government refuses to even acknowledge there is a problem, let alone do anything about the problem. Acting Speaker, I have to acknowledge the incredible work of Boroondara Police, and particularly Inspector Sandy McIver and her team at Boroondara Police Station. They have a very tough job, and they have a very tough job at the moment where they do have a lack of resources and a lack of support from this government. And I'll be joining them on Thursday morning as they do take 30 minutes out of their day to send a message to the government that they do need more support. They deserve a government that is going to come to the table and actually negotiate and sit down with them and understand their concerns and make sure that they are being heard. At the moment, that is simply not happening. We have a government that has found itself, by their own incompetence over 10 years, in financial ruin and now can't afford to actually pay our frontline workers what they deserve to be done every single day when they're out protecting our community. So, Acting Speaker, I return to the bill and how it deals with our criminal justice proceedings. I thank the member for Malvern for his reasoned amendment. The Coalition will not be opposing the bill before us today, but we do encourage to do a review to make sure we actually get this right.
Member